didn't do what had to be done from a defendant's standpoint. By the way, the number one was written by Judge Mazzarelli, and there was a dissent. I think the dissent was by Nardelli. In any event, here's what the court stated. Plaintiff testified at her deposition that she knew at the time of the accident that there was a step stool with 2 steps in a supply closet maintained by her employer, but never asked for it. And then the court pointed out the following, and I think this is very important for all the defendants, carriers, representatives out here, when you speak to the attorneys and ask what they're doing. Plaintiff was not asked at her deposition, nor does the record reveal how high the stool was. The court went on to state, the lack of clarity is not the result of conflicting factual allegations. Rather, it is because defendants failed to set forth any evidence regarding the availability of the stool, even if it were clear the stool would have been provided had plaintiff asked. Defendants failed to produce evidence that it wasn't an adequate, that it would have been an adequate safety device. Now think about this. Lisa Sokoloff is from John Fabiani's office. If John had this case, I think that stool would be locked up in his safe. And you have it to think about it, because we all know office buildings, we know the windows. We don't know anything from this decision, because obviously no one ever asked, how high is this stool? Would the plaintiff have been able, using this stool, to not have to have climbed on the desk? Was this a safe, available safety device on the job site that the plaintiff was aware of, could have safely used, and prevented the accident from happening? You may have been able to establish both a sole proximate cause defense as well as a recalcitrant worker defense. And don't forget, when you look at when you're thinking about the recalcitrant worker defense, it's really the same analysis. The failure to use an available safety device is a sole proximate cause of the accident. So it's sort of the same analysis. But it points out again, as defendants, this pendulum has swung. You have a lot more to work with now. If you have a plaintiff now come in and ask those old silly questions, were you the owner? Yeah, the GC, yeah, the scaffold fall, yeah, goodbye, you can start smiling and start, all guns blazing and have a very good chance of, if not winning the case on a motion, going to the jury on a question of fact. The next important Court of Appeals case I want to talk to you about, and frankly, I don't quite get it. Maybe during the break somebody here can explain it to me, is Montgomery versus Federal Express, which was a 2005 Court of Appeals case. I'm sure you're all aware of it. It's at page 102. Plaintiff in that case was employed as a helper by an elevator company working under the direction of an elevator mechanic. Okay, get this, it's important. A helper. Those of you who have had elevator cases know the mechanic's in charge, the helper's usually an apprentice working under the authority of the mechanic, okay? So he's working under the authority of the elevator mechanic. And they're assigned to work in an elevator motor room about 4 feet above the roof level of the building. The stairs, which led from the roof to the motor room, had been removed. In this case, the Court of Appeals affirmed summary judgment for the defendant. And they stated, although there was no ladder in the immediate vicinity, ladders were available somewhere at the job site. And plaintiff and the mechanic had turned over a bucket and stood on it and in the motor room, and then when they're trying to get down, plaintiff jumps because he can't reach the bucket and he's injured. The court held, since ladders were readily available, plaintiff's normal, get this, plaintiff's normal and logical response should have been to go get one. Plaintiff's choice to use a bucket to get up and then to jump down was the sole proximate cause of his injury. What about the fact that the plaintiff was merely a helper, working under the direct supervision of a mechanic, who in an elevator situation like this is in effect a supervisor? What about the fact that ladders were not in place at the job location at the site of the accident? They maybe were somewhere there. And what about this? There's nothing in that record in Montgomery, which is a very short, it's like a page and a half. There's nothing in that record that plaintiff knew ladders were available. Nothing. In one way or the other. It doesn't say whether he knew or he didn't know. But his logical response should have been to get one that may or may not have been around. There's a very interesting, and this is why, listen, the law, this pendulum, the law is starting, and you'll see, to swing back. It's never, and I'm not saying it should, going to swing back to 1978 and Jack Fuchsberg's decision in Hames. But as we all know, when we have these swinging effects or pendulum effects in the law, they go all the way one way, then they go all the way the other way. Then they come back to maybe a more reasonable ground for both plaintiffs and defendants. There's a recent Fourth Department case, which I think is very interesting. It was decided in October of 2008. Its name of the case is Baker versus Essex Homes. The site is 864 subsecond 822. Brian has it in a footnote at page 54 of his submission. Here's what happened. Plaintiff was standing on a bundle of shingles while he was repairing a roof and fell when the bundles, which were held in place by roofing spikes, broke apart under his feet. Court held summary judgment for the plaintiff. They stated, it is undisputed that there were no safety devices in place to protect, remember the old law, in place at the site of the accident. There were no safety devices in place to protect plaintiff from falling from the roof. And the absence of appropriate safety devices in place to protect plaintiff from falling from the roof established as a matter of law that their absence was the proximate cause of the injury.